Legal AF. The drum beats are getting louder to disqualify Donald Trump from being on any ballot, primary, or general election because he has disqualified himself under the 14th Amendment of the Constitution, Article 3, by engaging in insurrection or rebellion. Not convicted of it, right? Not after a court has decided, just that he has engaged. We reported earlier on at least one other lawsuit that was filed last week in Florida, in Palm Beach County, against Donald Trump himself by a tax lawyer, Lewis Kaplan versus Donald Trump, seeking a declaratory judgment that Donald Trump was not eligible. However, what I think is the better case so far is the one just filed in the last day by Robert Davis, an activist who uses the court system to achieve political ends. He is filed against some unique laws in the state of Michigan, and in this case, suing the Michigan Secretary of State, Jocelyn Benson, a Democrat and former dean of a law school, Wayne State Law School, suing her in her official capacity for what's called a mandamus to stop her from ever placing Donald Trump on the ballot for the Republican primary at all, by arguing, and I think correctly, that Donald Trump has engaged, that's the constitutional word chosen by the framers, by the people that framed the 14th Amendment and brought it into fruition after the American Civil War, and as it being applied to Donald Trump. I think Davis is onto something. As I've said in other hot takes, the right angle for this is to take a page out of the Republican playbook. Don't just file willy-nilly in any state. Find a state that has a unique set of laws, has a judge that's favorable to the position that's being advocated. Just like the Republicans go after Abilene, Texas, and a right-wing right to lifer sitting there as a federal judge on abortion issues, find the judge that's in our favor on election issues and bring this particular case. Robert Davis is onto something. Michigan has a very unique set of laws that gives the Secretary of State and the party chairperson of this case, the Republican Party, the right to put together a list based on national media reporting of who should be on the ballot. Some states you have to get signatures and to get yourself onto the ballot. You know, signatures of enough voters, or you have to pay a fee to be on the ballot. But Michigan gives the power to the Secretary of State. And I think Mr. Davis's plaintiff is onto something because he's got the right Secretary of State. Jocelyn Benson is a lawyer, previously a dean of a law school. She's a Democrat. And just to show you that I think he's right, on the 28th of August, she did a little bit of what I do here on the Midas Touch Network. She went on a podcast and she gave her testimony or her statement about how she would handle the issue of whether Donald Trump should be disqualified. And while she said she's going to follow the law, you can hear in her voice that she's open to the idea of disqualifying Donald Trump under the 14th Amendment. Let's roll the clip from her recent interview on a Michigan podcast.
I mean, could a state election official say, you know, because of Donald Trump and his indictments, we're not going to let him on our ballot?
As you know, that's something that a lot of legal scholars are weighing in on right now. I think the bottom line for me is we're going to follow the law. We're going to follow the Constitution. We're going to see how these constitutional and legal questions, which are not cut and dry, play out in the months ahead, not just in the primary process, but with ongoing legal questions as well, evolving. So I would just say to everyone, like, you know, it's going to be a quite a historic election cycle one way or the other. And I think we already see that unfolding with the candidates at play and the debates and the investigations and all the rest and the criminal indictments. Our job in Michigan as election administrators will be just to make sure that the process goes smoothly and that we operate by the book according to law in a way that in issues of, as you just, the example you just suggested, are really novel. We've never really had to grapple with something like that before. How are we doing so that complies with the law and the Constitution, but also is mindful of the precedent that's created, particularly in this era of false equivalency, where you have facts, and then you have aspersions and conspiracy theories. And how do we make sure the law is applied in a way that's rooted in facts and evidence always, and aligns with what legal precedent would suggest? So all of those factors. And then there's a question of who. Should it be the court? Should it be ultimately the U.S. Supreme Court who makes decisions like that, or weighs in on that, or in addition to state officials? So I think we should expect to see all of that unfold in the months ahead. And I have said for really since 2020 that this presidential cycle in 2024 is, I believe, in many ways going to be the grand finale of all of the bumps and the challenges we've seen and endured since the 2020 election cycle, maybe even since 2016. And there's a lot of variables and a lot of unknowns that have yet to play out. But from my standpoint, from my office's standpoint, from the Bureau's standpoint, the law and the Constitution will be our North Star, alongside the principles of protecting every voice and every vote for every Michigander.
So to be clear, Secretary, is it possible that Donald Trump won't make our presidential primary ballot because of these legal issues? Is that a possibility? I
would say there are valid legal arguments being made to that effect, but it's far too soon to really assess the likelihood of that, because a lot of the facts and the evidence and the legal analysis that all of that would have to be rooted in have still yet to be played out. But it's something that not just in our state, but colleagues in every state. I mean, the secretaries of state of multiple states are having conversations about just that. Democrats and Republicans, with, again, the clarity that we want to know what the law is and make a decision rooted in that, not in politics, but with a notion of what the reality is in this moment. So I'm talking with folks in Pennsylvania, with Secretary of States in Nevada, and even in Maine, people who in Georgia, of course, my colleague Brad Raffensperger, just to kind of get a sense of what the facts are, what the evidence is, what the timeline is, and but knowing there has been now, and there likely will be, an ongoing legal question about the former president's eligibility to be on the ballot, rooted in the 14th Amendment of the Constitution.
There you have it. You've got the right Secretary of State. You got the right set of unique state laws. You got a perfectly fine plaintiff because he's a voter in Michigan, and you have the right constitutional provision being invoked, which is Amendment 14, Article 3.